Hey guys, the topic for today is intellectual property. We will see the basic info of intellectual property. Hope you enjoy the video. Don't forget to like, share and subscribe. Before we see the meaning of intellectual property, let us see the meaning of property. Property means a thing or things belonging to someone. The term property includes both living and non-living things. It also includes a person's life, liberty, reputation, status, etc. Property is divided into two types: tangible and intangible property. Tangible property is the right of ownership on material things or tangible things, that is, things that cannot be touched and seen. Intangible property. Intangible property is also known as corporeal property. Intangible property cannot be seen or touched and includes valuable interests in respect of non-material things, which law has recognized and gives special protection. For example, trademark, copyright, goodwill, etc. And now, what is intellectual property? Intellectual property is an intangible property. Anything produced by human skill, intelligence, labor, and efforts are called the intellectual property. Intellectual property law confers on the owner the proprietary right over its products and authorizes him to take action against third parties for their acts of infringement over the intellectual property. The term intellectual property is used to refer the copyrights, trademarks, patents, industrial designs, and confidential information. Kinds of intellectual property rights. The major types of intellectual property rights are patent, copyright, right to trademark, right to industrial designs. Let's see what copyright is. It is the right to do or authorize others to do a certain act in literary, dramatic, musical, artistic works, cinema, and sound recording. Copyright is a product of human skill and mental capacity of some creative and original work. The rules regarding copyrights are governed by Copyright Act 1957. What is patent right? The patentee has the exclusive right to use the invention patented, to grant license to others, or to sell that right to a third party. The invention can be a new product or an improvement to an existing product. The rules regarding patent rights are governed by Patent Act 1970. Right to industrial designs. It is the right of the person who has developed the design to use and gain benefits. He can grant license for use by third parties or assign the right to a third party. The rules regarding design rights are governed by Designs Act 2000. Right to trademark. After registering a trademark, the owner of the registered trademark gets the right to prevent from using the trademark or to have a trademark which is deceptively similar to the registered trademark. These rules are governed by Trademarks Act 1999. We also have the layout designs of integrated circuits, where the designer has the exclusive right to apply for the registration of the layout design, and he can also grant license to be used by third party or assigned to any third party. Right to confidential information. The confidential information is protected by the owner to keep them secret and can take action against the unlawful use of such information by others by an action for breach of confidence or contract. And finally, we're going to see the term of protection of intellectual property. First, for copyright, that is the dramatic works, literary artworks, right in performance, protected for author's life and for another 50 years. Patent right. After registration of patent, priority date is fixed, and it's up to a maximum of 30 years. Trademarks. The registration of trademark is valid for 10 years and can be renewed from time to time. The trademark may be renewed for another 10 years from the date of expiration of the original registration on payment of prescribed fee. Designs Act. The owner of the design shall have the copyright or of design for 10 years from the date of registration, and if renewed on time, for another 5 years. Thanks for watching.